Hey gang, Stephen Marshall, KYLandlordlaw.com, and there has been a whirlwind of activity this week. So I want to give you a quick update here. So let's start at the beginning. A few weeks ago I mentioned that there was a group up in northern Kentucky that was contemplating filing a lawsuit against the governor if he didn't open things up soon for evictions. Well, that happened this week. I think it was filed on Tuesday of this week in federal court up in northern Kentucky. The lawsuit filed by the Greater Cincinnati Northern Kentucky Apartment Association and then 3 local apartment community owners. They filed suit against the governor and the circuit clerks in Boone, Kenton, and Campbell counties. Now, the lawsuit's limited to those 3 counties because that's where the property owners did business, so they only had legal standing to request relief in those counties. So if that suit is successful, it would not lead to evictions being opened up throughout the entire state, but only in those 3 counties. Now, there's a possibility that other groups are going to join this lawsuit in the very near future. And the joining of those other groups could expand the relief throughout the entire state. So we're going to keep an eye on that and see who joins. Hopefully there will be some groups join that would make that a statewide suit so that the relief would be throughout the entire state if the suit were to be successful. As I've said before, if you're interested, I'll be glad to put you in touch with the folks that are moving the suit forward. If you'd like to participate or like to contribute, just shoot me an email and I'll put you in touch with them there. So that was the first thing. The second thing happened yesterday afternoon. Most of you have heard about a recent lawsuit that was filed by Evans Orchard against the governor. Well, we got a bit of a jolt yesterday afternoon when the Scott County Circuit Judge Brian Privet issued a temporary restraining order against the governor and other state officials in that lawsuit. And the restraining order had 2 parts. And first, it directed the governor and these other state officials to cease enforcement of any executive order directed at Evans Orchard or any of the other 548 agritourism businesses registered with the Department of Agriculture. So that's first. And then second, and this is what got a lot of attention in the rental industry, it requires the governor to follow 3 guidelines before issuing or enforcing any executive order based on the state of emergency. 3 guidelines are that he must first identify the emergency that requires the order. He must identify the location of the emergency. And then third, he has to identify the name of the local emergency management agency that has determined that the emergency is beyond its capabilities. So this is an excellent ruling for those who care about the rule of law because it ensures that our executive officials, whether it's this governor or any future governor, is not going to arbitrarily and needlessly issue statewide orders when perhaps a local order is all that's needed. So the final effect of this temporary restraining order out of Scott County is far from clear. The governor indicated in his press conference yesterday that he's going to appeal it up to the state's higher courts. And so here's the question that I'm getting based on the second part of the order there. Does this mean that evictions for non-payment of rent are going to open up immediately? And unfortunately, the answer to that question is no. Regardless of whether the state's higher courts uphold the Scott County order, there's still another domino that would have to fall before evictions for non-payment of rent are allowed statewide. And that domino is that the Kentucky Supreme Court would have to issue an order directing the state courts to accept eviction filings based on the failure to pay rent. If you've watched my prior videos, I've told you that there's basically 2 things that have to happen. The governor has to issue an order allowing non-payment of rent evictions to go forward, and then the Kentucky Supreme Court would have to follow suit and issue its own order. Okay? Well, in this case, the Scott County judge has issued an order that basically enjoins the governor's order, perhaps, but that doesn't deal with this second domino of the Kentucky Supreme Court having to issue an order directing the local state district courts to accept eviction filings on non-payment of rent. So regardless of whether the Scott County ruling ends up being upheld, I don't expect it to open things up for evictions on a statewide basis, because all that would have to happen is that the governor would simply have to identify COVID-19 as the emergency that prompted his order prohibiting evictions. Then he'd have to identify counties where the virus has had significant effects, and then he'd have to get a local emergency management agency to state that the virus is beyond their capabilities. And I expect many, if not most of them, to do that, because I believe that some of their funding is tied to that. So I'm glad to see another court pushing back against executive overreach, but I don't expect it to have any significant effect on the rental industry, though we can hope. But I do hope that Evans Orchard can survive as a business, so hopefully that ruling will lead to that end. So, as if that wasn't enough, in his press conference yesterday, the governor announced he was issuing a new executive order mandating that we wear masks in public. And he did follow through and issue that executive order yesterday evening. I'll have a copy in its entirety on the website and the post that accompanies this video, so give that a look. The gist of the executive order is that masks are required in 3 situations. First, when you're inside or waiting in line to enter any establishment, when it's difficult to maintain 6 feet of separation from people who are not members of your own household. That's going to be things from grocery stores, retail shops, hair salons, restaurants, bars, pharmacies, all those types of places. When you're inside them or you're waiting in line to get inside them, you got to wear a mask according to the most recent order. Second, anytime you're using public transportation, whether that's buses, cabs, Uber, anything like that, got to wear a mask when you're riding or driving there. And then third, even in outdoor spaces where you cannot maintain 6 feet of separation. So those are the three scenarios. But there are a number of exceptions that we need to be aware of. There are 12 of them, as a matter of fact. First, children under 5 years old, exempt from wearing masks. Second, if you have a disability or a condition that prohibits you from wearing a mask safely, you do not have to wear a mask. Third, if you're hearing impaired or you're communicating with someone who's hearing impaired and you would need to remove the mask for lip reading, you don't have to wear a mask. Any workers that are prohibited by federal regulators from wearing masks for safety reasons are exempt. Anyone who is seated and eating or drinking at a restaurant or bar, okay, exempt from the mask requirement. So when you are waiting in line or waiting for a table, you're required to wear a mask. But once you're at your table and eating or drinking, don't have to wear a mask for restaurants and bars. Anyone who's performing or receiving a service that requires that your mask be off in order to perform or receive the service, again, exempt from the mask requirement. You're exempt if you need to remove the mask for security or identity purposes. For someone to see your face, you're exempt from the requirement during that time period. This one was interesting. Anyone who's giving a speech or a broadcast is exempt from the mask requirement as long as they can maintain 6 feet of separation. That one I'm sure came up because people noticed the irony of government officials giving these speeches without wearing a mask surrounded by people who also were not wearing masks. So that's what prompted that one, I'm sure. Number 9, this one is significant. Anyone in a swimming pool or other body of water, you don't have to wear a mask. Number 10, anyone exercising in a gym where you can maintain 6 feet of separation from the other people, no mask required. Anyone engaged in athletic practices or competitions, no mask required. And then finally, any time when state or federal law otherwise prohibits wearing a mask, you don't have to wear a mask. So, in the rental industry, outside of those exceptions, property managers and your staff are directed to wear masks, and you are directed to require your tenants, applicants, vendors, prospects to wear masks while using your indoor common areas. So that is now a directive from the governor. Do with that what you will, and that's all I'll say about that. And so finally, in closing, this is the question I get asked every day. When are evictions for non-payment going to open up, folks? I have no idea. I'm going to keep you updated on the status of this lawsuit in Northern Kentucky against the governor. And until we have something on that, I encourage you to continue to send letters to the governor and your state legislators. With each passing day, the number of evictions that will need to be filed later increases. So if our state officials and other advocates want to prevent a flood of evictions, things need to open up sooner rather than later. And I think I've mentioned this before. I've got a draft letter that you can send to the governor and your legislators. If you're interested in that, just shoot me an email and I'll get it to you. It's a $100 project, but I'll be glad to provide you with that. So it's been a whirlwind of a week, but the weekend is upon us. So that's it. You guys have a fantastic weekend. I'm sure we'll talk next week as things develop in this lawsuit. Take care.